which it has found to be established. And so it's for the court to consider whether in totality the evidence before you, in the case brought by the Gambia, stands up. There's no single type of evidence or method of proof that the court restricts parties to rely on. Evidence from any source can be taken into account, and it will be for the court to assess its credibility, reliability, and probative value to the issues in question. It is for the party alleging a fact to demonstrate its existence. But even this, in the court's practice, is not an absolute rule. As the court has said, the determination of the burden of proof is in reality dependent on the subject matter and the nature of the dispute brought before the court. It varies according to the type of facts which is necessary to establish for the purposes of the decision of the case. So the court takes an inherently, and we say appropriately, flexible approach to the evidence it is prepared to receive and consider in order to ensure that it is equipped with the materials necessary to make its own determination of the facts and to apply to those facts the relevant rules of international law. Mr. Reichler is going to address this in detail. The Gambia's evidence, its reliability and its probative value will be a matter for him. Suffice it to say at this early stage, the totality, the body of evidence presented by the Gambia on this application, fully underpinned, as it is, by the careful, thorough investigations of the UNFFM and the many eyewitness accounts that were collected by that body, is compelling and persuasive. To take the words of the court, it is convincing. It provides a strong foundation for the court to reach conclusions on the facts and to find that the Rohingya genocide is clearly established. Mr. President, members of the court, I've addressed the existing legal standards for proving genocide under the 1948 Convention in general terms, including proof of dolus specialis. These standards build directly on the approach set forth by Raphael Lemkin in his book, Axis Rule. And so I'm going to conclude by returning to where I began. New conceptions require new terms, Lemkin wrote in November 1944. He noted in these pages the evolution of international law having brought about a considerable interest in national groups, as distinguished from states and individuals. He invented the concept of genocide to deal with that evolution. And by genocide, he wrote, we mean the destruction of a nation or of an ethnic group. This occurred, he continued, as a composite of different acts of persecution or destruction. And on his interpretation, they occurred in two phases. One, these are his words, destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. And he continued, the oppressed who were the subject of genocidal acts could remain or they could be removed. The oppressed were always members of certain national groups who lived as minorities. And I quote him, if these groups should not be adequately protected, such lack of protection would result in international disturbances, especially in the form of disorganized emigration of the persecuted who would look for refuge elsewhere. End of quote. And against this background of what he saw between 1933 and 1945, he proposed, quote, an international multilateral treaty should provide for the introduction of provisions protecting minority groups from oppression because of their nationhood, religion, or race. The 1948 Convention is that international multilateral treaty. And Lemkin's words, written in 1944, and Article 2 of the 1948 Convention capture, regrettably but exactly, what has happened to the Rohingya. Lemkin's assessment back in the 1940s was the product of a meticulous exercise of research and reflection. His book and the Convention are testament to the power of ideas, to their reduction into a written and legal form, and to their capacity to hope for the world as a better and safer place. Raphael Lemkin lived through terrible times, just as the Rohingya have. But at no point did he, or his colleague Hirsch Lauterpacht, or so many others like them, choose to curl up in a corner and weep, or conclude that action or international rules were pointless. And the Rohingya have adopted exactly the same approach. And so has the Gambia, whose Attorney General you heard from this morning. That is why the Gambia is here today. Mr. President, the Genocide Convention, including its Article 2, really matter. And so does its meaningful and effective interpretation and application on the facts of this case to the situation regarding the Rohingya. It's to that issue that Mr. Reichler will now turn, and perhaps, after a brief pause, you would call him to the bar. I thank you for your attention.
I thank Professor Sands. Before I give the floor to the next speaker, the court will observe a break of 50 minutes. The hearing is suspended.